Breaking news as we come on the air. A federal judge has ordered the Trump administration to reinstate thousands of probationary employees who were fired last month from a half dozen federal agencies. Those agencies are the Department of Veterans Affairs, Agriculture, Defense, Energy, Interior, and the Treasury. The judge found the firings did not follow federal law and requires immediate offers of reinstatement be sent. The order from the San Francisco-based judge came after a lawsuit filed by a coalition of labor unions and organizations. There are certainly a lot of questions about what this ruling means for those federal workers, so we want to bring in John Hatton with the National Association of Active and Retired Federal Employees. John, thank you for being here again.
Thank you for having me.
So what are you hearing about this ruling from your members?
Well, it just came down, so I think we're still going to be waiting to see what people are saying, but I expect people who are fired as probationary employees will find this welcome news. Now, this is a district court ruling. I expect the administration to appeal the ruling, but in the near term, this is certainly welcome news for individuals who are terminated from their positions for no real good reason. One of the things the judge said was, essentially, agencies were making up a potential lie that people were fired for poor performance when that was anything but the case. We had cases where, people were probationary because they were in a new position or at a new agency, but they had years of service for the federal government, and particularly years of quality and high performing service. So it's great to see this action taken. And if the Trump administration needs to have a reduction in force, it's got to do it the right way.
Reinstatement means going back to the position that you were let go of, but this does not mean that they couldn't be let go again. Is this a worry?
Yes, that still will be a worry. President Trump has directed agencies to have reductions in force and reorganizations. So plans for those reductions in force and reorganizations, phase one, are due today. Another phase two will be due in April. So these probationary employees may be tied up in those potential reductions in force as well. We don't know the extent of those yet, but the fact that they might have been a high performing employee, what tenure they have on the job. So if they are somebody who has long tenure in service for an agency or for the federal government, that would help them out. So it's a more orderly process to do a reduction in force based on what the statute says.
With this reinstatement, do we know if it comes with back pay for as long as they've been away from the job?
I expect it might, but it was a ruling from the bench today, so we will have to see what the implications of that ruling would be. But if it was done incorrectly, I expect it would.
Is this a bit of a job whiplash that your members are facing, because not only do they not know where they stand, it can go from one day being fired, the next day being reinstated, and then not knowing what the future can hold?
Yeah, there's a lot of uncertainty for federal jobs right now. This is just one piece of good news to kind of make sure the administration is following the law and taking these personnel actions. And so, of course, it's going to be tough for employees in these situations, not just these probationary employees, but federal workers across the government who are facing the unknown of what's going to happen with reductions in force, with the potential that people we've moved out of the competitive service and into pseudo at-will positions to try to give the administration more power to fire them and put in political appointees.
Now, this is 6 departments in the federal government, not all. One missing, which I noted, is that the Department of Education was not one of the departments listed here. Do you think that there could be more agencies that will follow along this judge's order if it goes through?
Yeah, certainly. I think if it's the same reasoning applied, it could apply to other agencies if court cases address those issues. I think the main thing the judge said here was, this was essentially ordered by the Office of Personnel Management that didn't have the authority to do that. It was not an appropriate agency action, and agencies appeared to be following the directive of the Office of Personnel Management. essentially run by the Department of Government Efficiency. So if these types of activities in terms of reducing force, downsizing the federal government are going to go forward, they should be done appropriately through the agencies, through the process that is laid out in statute. Now, we're going to have problems with and object to large scale reductions in force. The federal government has actually shrunk in size in terms of the total workforce since the 1960s and 1970s, while the population of the United States and the workforce has grown significantly. Where you've seen increases in the workforce serving the federal government, it's in the contractor workforce, not in the civilian workforce. So we don't think these are good policies, but certainly they need to be carried out in a way that is legal and based on the statute.
John Hatton with the National Association of Active and Retired Federal Employees, thank you for your insight.
Thank you for having me.